In 43 years on this bench, I have watched people lie to me in every way a human being is capable of lying. I have watched them lie with tears running down their faces. I have watched them lie while holding a Bible. I have watched them lie so convincingly that the people sitting 3 feet away from them believed every word. But on the morning of September 9th at 9:52 a.m. in courtroom 7 of the Miami-Dade County Civil Division, I watched a woman do something I have never seen in 4 decades of jurisprudence. She lied under oath directly to my face with complete, practiced, almost artistic calm, and she had no idea, not the faintest idea, that 47 minutes earlier, a building security camera on the 3rd floor of this very courthouse had recorded every single thing she had said and done and planned in the elevator on the way up. 30 seconds of footage. That is all it took. Stay right where you are, because what you are about to hear will make you question everything you think you know about how far some people will go and how short a distance truth has to travel to catch them. Daniel Reyes was 47 years old, and he was the kind of man this world quietly depends on and rarely thanks. He had spent 22 years as a licensed structural engineer for Miami-Dade County, the person who signs off on whether a building is safe before a single family moves into it. He was not famous. He did not work in a corner office with his name on the door. He worked in a county building with fluorescent lighting and a parking spot that flooded every time it rained, and he showed up every single morning at 7:15 a.m. because the work mattered. Daniel had grown up in Hialeah, the second of 4 children, raised by a single mother who worked double shifts at a hotel laundry facility for 19 years to keep the lights on. He put himself through Florida International University on a combination of Pell Grants, a partial academic scholarship, and weekend work at a landscaping company. He graduated with a 3.8 GPA. He sent money home every month for 6 years after graduation until his mother retired. That is who Daniel Reyes was. By the time he walked into my courtroom, Daniel was also a father. His daughter, Sophia, was 9 years old. She had been diagnosed with juvenile idiopathic arthritis at age 6. A condition that had required 4 hospitalizations, 2 joint procedures, and a specialist regimen that cost, after insurance, approximately $1,400 a month out of pocket. Daniel had never once missed a payment. He had never once missed a school pickup, a hospital appointment, or a bedtime, even on the nights he worked until 9. He had been with his girlfriend, Vanessa Crane, for 3 years. They had moved in together 18 months prior into a 2-bedroom apartment in Doral that Daniel owned outright. Purchased before they met, paid down early through years of careful saving. When they moved in together, Daniel had, at Vanessa's request, added her name to the utility accounts and given her access to the household account to manage shared expenses. He trusted her the way people trust someone they believe they are going to spend their life with. That account, over the following 14 months, saw $63,000 quietly leave it in transfers Daniel could not explain. When he began asking questions, Vanessa told him he was being paranoid, that he was controlling, that his stress about Sophia's medical bills was making him see problems that didn't exist. He believed her. For 3 months, he believed her. The morning he finally pulled the full bank statement and sat at his kitchen table at midnight going through every line, that was the morning Daniel Reyes understood that the most dangerous lies are the ones told by the people you never thought to doubt. By the time I met him, he had not slept properly in 6 weeks. His eyes told me everything. Vanessa Crane was 41 years old, and she arrived in my courtroom looking like a woman who had never once in her life been told no. She was wearing a Veronica Beard blazer, the kind that retails at approximately $695, over tailored Vince trousers at $380, with Bottega Veneta mules that I recognized because a previous defendant had once tried to sell a pair to cover her legal fees. Those run close to $900. Her hair was blown out, her jewelry was understated and expensive in the way that only expensive jewelry can be. A Cartier love bracelet on her left wrist, retails $6,900. She came accompanied by her attorney, a man named Fletcher Drummond, whose downtown firm charges $580 an hour and who had, I was informed, already filed 3 pretrial motions attempting to exclude the security footage from evidence. 3 motions, all denied. Vanessa had, prior to her relationship with Daniel, worked as a client relations manager at a private wealth advisory firm, a position that gave her, for 7 years, daily proximity to significant sums of money that belonged to other people. She had left that position, I noted in the file, following an internal audit. No charges were filed. The matter was settled privately. She had told Daniel she left because the corporate culture was toxic. She carried herself in my courtroom with the particular quality I have learned over 43 years to recognize immediately, the confidence of someone who has done this before and gotten away with it. Not arrogance exactly, something colder than arrogance. A kind of patient certainty that the system would bend toward her the way it apparently always had. She did not look at Daniel when she entered. She looked at me, assessed me the way I imagined she assessed every room she walked into. And then she looked at her attorney and said something behind her hand that made him nod once and write something on his legal pad. I made a note of my own. She has done this before. The original incident that brought this case to my courtroom occurred on July 22nd at approximately 6:40 p.m. in the parking garage of the Doral Commons shopping center. Daniel had asked Vanessa, calmly and in writing, he texted her, which matters because that text was later entered as Exhibit 3, to meet him that evening so he could go through the bank statements with her in person. He had printed them. He had highlighted the transactions he couldn't account for. He had organized them chronologically, the way an engineer organizes everything, because Daniel Reyes believed that if you presented facts clearly enough, people would engage with them honestly. He sat in his car in that parking garage and he waited. Vanessa arrived 11 minutes late. She sat in the passenger seat, looked at the printed statements he placed on the center console, and she did not pick them up. "You need to stop obsessing over this," she told him. "This is what I'm talking about. This is the controlling behavior." Daniel pointed to a transfer dated March 4th. $4,200 to an account he didn't recognize. "Vanessa, whose account is this?" She turned to look at him directly. "A friend who needed help. I told you about it." She had not told him about it. He had never heard this name before. He said so. What Vanessa said next, and I want you to hear this clearly, because Daniel submitted a written account of these exact words in his pretrial declaration, case number 2024 CF 08847, was this: "If you keep pushing this, I will tell everyone you hit me. I have friends, Daniel. I will make your life very small." He sat very still. She picked up her bag, got out of the car, and walked away across the parking garage without looking back. Daniel Reyes sat in that car for 22 minutes. He told me later that he spent most of those minutes thinking about Sophia, about what a custody dispute would look like, about what an accusation like that would do to his job, his license, his ability to provide her medical coverage. He was afraid. He had every reason to be afraid. But when he drove home that night, he did one thing before he went inside. He went back through every notification, every account alert, every transfer confirmation in his email going back 14 months, and he forwarded every single one to a dedicated folder. Then he called a lawyer. The lawyer told him to document everything going forward, to be patient, to let the evidence build. Daniel Reyes was, if nothing else, a man who knew how to be patient. He also, before he went to sleep that night, reviewed the lease agreement on his Doral apartment, the one he owned, and noticed that Vanessa's name appeared nowhere on the title, only on the utility accounts. He made a quiet phone call to his bank the following morning and removed her access to the household account. What he did not know, what neither of them knew, was that Fletcher Drummond's aggressive pre-trial strategy would eventually require Vanessa to appear in person at the courthouse for a document review session, and that the third-floor elevator had been recording in HD since 2021. The morning of September 9th, Daniel arrived at the courthouse at 8:30 a.m. He was wearing a charcoal gray suit that fit him well and had clearly been pressed carefully the night before. He carried a single manila folder and a legal pad. He had shaved. His shoes were clean. He looked like what he was, a professional man who had spent 22 years showing up prepared. He was accompanied by his attorney, a woman named Marguerite Solano, who had been practicing family and civil law in Miami-Dade for 16 years and who had the quiet, efficient energy of someone who did not waste a single word in a courtroom. He sat down, placed his folder on the table, and folded his hands on top of it. He did not look at Vanessa when she entered. Vanessa and Fletcher Drummond arrived at 9:41 a.m. Drummond was carrying a leather litigation bag, the kind that announces its price through its simplicity, and a banker's box of documents he set down with deliberate weight, as though the mass of paper itself was a legal argument. Vanessa sat, crossed her legs, and smoothed her blazer. She glanced once around the courtroom, then she looked at me. I have been looked at by a great many people in this room over 43 years. Judges develop, whether they want to or not, a sensitivity to how different people look at the bench. Some look with fear, some with relief, some with the desperate hope of people who have run out of other options. Vanessa Crane looked at me the way someone looks at a problem they have already solved. I want to be precise about what I was thinking in that moment, because it matters to what came next. I was thinking, I have 3 motions to deny, testimony to hear, and evidence to review. I was thinking about Daniel's daughter, Sophia, whose photograph was in the file, smiling from a hospital bed in a shirt that said, "Brave Crew." I was thinking, let's see what the truth looks like today. Marguerite Solano presented Daniel's testimony first, and she did so with the efficiency of someone who understood that simplicity is the most powerful tool in a courtroom. Daniel walked through 14 months of transactions. He was specific. He had case numbers, transfer dates, receiving account identifiers, and a forensic accounting summary prepared by a certified fraud examiner, Exhibit 11, that mapped every dollar against its destination. His voice was steady. His hands were still. He answered every question directly, and when he didn't know something precisely, he said so. That last part matters. In 43 years, I have learned that the people telling the truth are always the ones willing to say, "I don't know." Marguerite then entered the bank records, Exhibits 1 through 9, which documented $6,400 in transfers across 14 months, flowing to 3 separate accounts. 2 of those accounts, the forensic examiner testified, were registered to shell entities with no verifiable business activity. The third was a personal account in the name of a man named Troy Weston, whose relationship to Vanessa was not, at that stage, on the record. It would be shortly. When Drummond rose for cross-examination, he attempted to characterize the transfers as jointly agreed household management, a narrative that required the jury, or in this case me, to believe that Daniel Reyes, a man who tracked his daughter's medication costs to the dollar, had simply not noticed $63,000 leaving his account. I let Drummond finish his cross. Then I asked Daniel directly, "Mr. Reyes, did you ever verbally or in writing authorize Ms. Crane to transfer funds to any of these 3 accounts?" "No, Your Honor. Never." "Were you aware of the accounts prior to your review of the statements?" "No, Your Honor." I turned to Vanessa. "Ms. Crane, you've heard the testimony and reviewed the exhibits. Is there anything in Mr. Reyes's account you disagree with?" Vanessa straightened. She looked at me with that same solved problem composure. "Yes, Your Honor. All of those transfers were discussed with Daniel in advance. He's confused because of the stress he's been under. He has a daughter with a serious illness, and frankly, I'm concerned his memory has been affected." The room was quiet. Drummond wrote something on his legal pad. I watched him. His jaw had tightened by approximately 1/16 of an inch. In 43 years, you learn to read attorneys' jaws. He had not known she was going to say that. I made a note. And then I looked at Marguerite Solano, who had been waiting with the patience of someone holding 4 aces for exactly this moment. "Ms. Solano," I said, "you may present Exhibit 12. Before Marguerite could stand, Fletcher Drummond was on his feet. "Your Honor, we've filed 3 motions regarding the admissibility of this exhibit. The recording was obtained without my client's knowledge in a—" "Mr. Drummond," I said, "I denied all 3 motions, in writing, twice. Your Honor, with respect, the 4th Amendment implications of courthouse surveillance footage used in civil—" "Mr. Drummond," I set my pen down. "Sit down." He sat. "But Vanessa, and this is the moment I want you to understand, because it tells you everything about who she is." Vanessa leaned toward him and said clearly enough that the court reporter captured it, "This is ridiculous. Do you know how many times I've sat in rooms like this and walked out fine? This judge doesn't know who she's dealing with." The court reporter looked up. I looked at Vanessa. The room went completely, utterly silent. The kind of silence that has weight. In 43 years, people have said a great many things in my courtroom that they later wish they had not said. I have been called names I will not repeat here. I have had objects thrown in my general direction. I have had an attorney once memorably attempt to file a motion while crying. But there is a specific category of statement, the statement made by someone so certain of their own invincibility that they have stopped calculating consequences. that I find clarifying. This judge doesn't know who she's dealing with. I wrote the quote verbatim on my notepad. I dated and timed it. I looked at Vanessa Crane and I thought about Daniel sitting at a kitchen table at midnight going through bank statements. I thought about Sophia in her Brave Crew shirt. I thought about 22 years of Daniel Reyes showing up. And then I thought, I know exactly who I'm dealing with. Ms. Solano, I said very calmly. Exhibit 12, please. I want to stop here and ask you something directly. If you were sitting in that courtroom, if you had watched this woman dismiss a man's documented evidence, suggest his memory was failing, and then tell a federal courtroom she'd walked out of situations like this before, what would you have done? Drop your answer in the comments right now, because what happens in the next 4 minutes will not disappoint you. Exhibit 12 was a video file. 22 seconds of footage from the third-floor courthouse elevator security camera, time-stamped September 9th at 9:08 a.m., 47 minutes before Vanessa took the stand. Marguerite pressed play. The footage showed Vanessa and Fletcher Drummond entering the elevator on the third floor. The audio was clear. Building security cameras in Miami-Dade courthouses have recorded audio since 2021, a policy change made after a witness tampering incident that I will not detail here, but that resulted in significant infrastructure upgrades. On the footage, Vanessa was speaking. Her voice was composed and businesslike. When she asks about the Troy account, I'm going to say Daniel approved it in conversation. He can't prove he didn't. He has no recordings, no texts. It's my word. Drummond, on the footage, said nothing for a moment. Then, Vanessa, I need you to be careful. Fletcher, I have done this before. I know exactly what I'm doing. Just let me talk. 22 seconds. That was the whole thing. Marguerite stopped the playback. I looked at Vanessa. For the first time since she had walked into my courtroom, the composure that studied, practiced, load-bearing composure cracked. Not dramatically, not in tears. It was smaller than that and worse. Her eyes moved to Drummond, not for reassurance, asking him a question without words, the way people do when they are trying to understand how something that should have been controlled became uncontrollable. He looked at the table. But here is the part that the footage itself did not show. The part that Marguerite presented next, through a declaration submitted by Special Agent Renee Okafor of the FBI's Miami field office. The Troy Weston account and the personal account receiving $31,000 of Daniel's money had been under federal financial surveillance for 8 months. Troy Weston was a person of interest in a wire fraud investigation involving 11 victims across 3 states. Vanessa Crane had been identified as a connected party 4 months into that investigation. The civil proceeding in Courtroom 7 that morning had been, in part, the reason Agent Okafor was already in the building. She had been watching the proceeding from the gallery, in a gray blazer, 3rd row, left side. I had noticed her when she sat down. I noticed most things. I looked at Vanessa Crane and I thought, the walls of this room have been closing for 8 months, and she walked in this morning and decorated them. Mr. Drummond, I said, I'm going to give you 5 minutes. He was already gathering his papers. What happened in the next 4 minutes and 11 seconds is in the court record under case number 2024 CF 08847, and I will recount it here precisely. During the 5-minute recess I granted, Vanessa Crane stood, picked up her handbag, and walked toward the courtroom exit at a pace that was not quite running but was not walking either. My bailiff, Officer Raymond Tate, 21 years with Miami-Dade, 8 years prior service as a Marine Corps military police officer, a man I have worked alongside long enough to trust completely, moved to intercept her at the door. 1. She pushed past him. 2, 3. He caught her by the elbow, firmly and without aggression. Standard procedure. She turned and swung her handbag at him with both hands. 4, 5, 6. Officer Tate, who has the reflexes of a man who has spent 29 combined years in situations considerably more dangerous than a Miami-Dade civil courtroom, stepped back, maintained contact, and said one word. Calm, flat, final. Stop. 7, 8. She stopped. Not because she wanted to, because in that 8th second, the gallery door opened from the outside, and Agent Renee Okafor stepped through it, badge in hand, accompanied by 2 additional agents whose jackets were very clearly marked. 9, 10. I had not moved, I had not raised my voice, I had put my pen down on the bench, and I had watched. In 43 years, I have seen a great many things unfold in this room. I have learned that a judge's stillness is itself a kind of authority, so that when everything around you is motion and noise, the person who does not move is the person everyone looks at. Everyone was looking at me. I waited until the room was completely still. Then I said, to no one in particular and everyone at once, "Sit down." Everyone sat. It took exactly 10 seconds from the moment Vanessa Crane stood to the moment the room was still again. 10 seconds for 43 years of practiced certainty to come apart. I looked at Daniel Reyes. He had not moved either. His hands were flat on the table. His folder was still in front of him. He was breathing slowly and deliberately. The way I imagined a man breathes when the thing he was afraid might never happen has finally, irrevocably happened. I gave myself exactly 3 seconds of private thought. Then I looked at Agent Okafor. "Agent," I said, "the courtroom is yours. If you've made it this far, you already know why this story matters. It's not just about one woman in one courtroom. It's about every person who has been told their instincts were wrong. Every person who sat at a kitchen table at midnight with a bank statement and knew the truth before anyone else believed them. Share this video right now. Someone in your life needs to see it today." Agent Renee Okafor was a 12-year veteran of the FBI's Miami field office, assigned to the Financial Crimes Task Force. She was 44 years old, composed, and carried herself with the particular quiet authority of someone who has spent a decade and a half untangling the kind of damage that people like Vanessa Crane leave behind in other people's lives. She read the charges into the record clearly and without drama, the way people do when the facts are already doing all the necessary work. Wire fraud, bank fraud, unauthorized account access, identity fraud, theft by deception, conspiracy to commit financial fraud, perjury, 2 counts for the testimony given that morning, obstruction of a federal investigation, tampering with a financial witness. This charge relating to a separate victim in the Weston network, a 68-year-old retired schoolteacher in Broward County who had lost $47,000. 8 charges, each read clearly, each landing in the silence of a courtroom that had stopped breathing. Fletcher Drummond did not speak. He had placed his legal pad face down on the table, which I have always found to be the posture of a man who has decided that whatever is written on it is no longer relevant. After the agents escorted Vanessa out, I called a 30-minute recess and returned to my chambers. I sat at my desk. I have a photograph in my chambers. It has been there for 19 years, of my parents standing in front of the courthouse where my father worked as a janitor for 31 years. He mopped the floors of buildings where decisions were made that affected his life without his input. He believed, despite everything, that those buildings were also his, that the law lived in them for everyone. I looked at that photograph for a long time. There was a knock at my door. It was Marguerite Solano, and behind her, Daniel Reyes. He was not crying. He was holding his manila folder against his chest, and he looked at me with the expression of a man who has just put down something very heavy. "Your Honor," he said. "Thank you." I told him to sit down for a moment. "Thank you, Mr. Reyes," I said, "for not backing down." I returned to the bench at 2:15 p.m. The courtroom was quieter than it had been all morning. The particular quiet that follows something significant when everyone in the room understands they have witnessed something that will not be ordinary to recall. I delivered my civil ruling first because the law required it and because Daniel Reyes had waited long enough. The $63,400 in transferred funds was ordered returned in full, with statutory interest accruing from the date of first unauthorized transfer. Vanessa's access to any remaining jointly held utility or financial accounts was immediately revoked. The Doral apartment, Daniel's property in Daniel's name, was uncontested. Then I read the following statement into the record, and I want to be precise because I wrote it in chambers during the 30-minute recess, and I meant every word. This court has heard testimony today from a man who spent 22 years certifying that the structures people trust to hold them up are sound. He did that work carefully. He did it with integrity. He applied that same standard to every part of his life, to his finances, to his daughter's care, to his decision to pursue this matter through the proper channels rather than respond to threats with threats. Across this table sat someone who mistook that integrity for weakness, who believed that a man who trusts carefully can be exploited permanently, who walked into this courtroom this morning and looked at the bench, looked at me, and calculated that the truth was manageable. The truth is never manageable. It is only delayed. What Mr. Reyes represents in this courtroom today is not the exception. It is the standard. The standard this court exists to protect. The standard this bench was built to honor. Court finds in full for the plaintiff. All relief requested is granted. So ordered. I set down my pen. Daniel sat with his hands folded and his eyes forward. Marguerite Solano made a single note on her legal pad and capped her pen. That was enough. Vanessa Crane's criminal trial concluded on March 3rd of the following year, approximately 6 months after the events in Courtroom 7. The jury deliberated for 4 hours and 51 minutes. They returned with guilty verdicts on 6 of the 8 charges, including wire fraud, bank fraud, perjury on both counts, and obstruction of a federal investigation. The 2 charges on which she was not convicted, identity fraud and conspiracy, were set aside due to evidentiary overlap with the Weston matter, which was proceeding through a separate federal docket. Sentencing was handled by United States District Judge Patricia Marlowe of the Southern District of Florida, who has been on the federal bench for 17 years and is not, from what I know of her reputation, a person who is moved by theatrical displays of remorse. Judge Marlowe sentenced Vanessa Crane to 7 years and 4 months in federal prison, to be served without the possibility of early release under the specific fraud statutes applied. She was ordered to pay $247,000 in restitution across all identified victims, including the 68-year-old retired teacher in Broward County, whose name I will not share here, but whose loss Judge Marlowe specifically referenced in her sentencing remarks. Troy Weston entered a guilty plea separately and received 9 years. Fletcher Drummond faced a state bar disciplinary proceeding. His law license was suspended for 14 months pending a full ethics review. The Cartier bracelet was seized as proceeds of fraudulent activity. I read that last detail in the case summary and I thought, there it is. 3 weeks after the civil ruling, Daniel Reyes received a commendation from the Miami-Dade County Department of Civil Engineering, not for the case, but for a structural review he had completed during that period on a public school building in Homestead that identified a foundation concern that, had it gone unaddressed, would have required emergency evacuation of 400 students. He had submitted that report on a Wednesday morning. His case had been the Tuesday before. He had shown up to work the next day. A fundraising effort organized informally through his daughter's school community, parents, teachers, a few former colleagues, raised $41,000 over 6 weeks, earmarked for Sophia's ongoing medical costs. Daniel tried to decline it. They didn't let him. Sophia, I was told by Marguerite Solano, who stayed in touch with the family, had had her most stable 6-month stretch since her diagnosis. Her specialist described her inflammation markers as meaningfully improved. She had joined her school's swim team. She sent me a card. A child's card, with a hand-drawn image of a courtroom, triangular judge's hat, gavel, a figure in a robe, and a sentence inside in careful print. Thank you for believing my dad. I have that card. It is next to the photograph of my parents. There are days when those 2 things are the reason I come back to this bench. Here is what 43 years has taught me, distilled to its simplest form. Justice is not a system. It is a choice. It is chosen, or not chosen, by individuals in moments, one at a time. By the person who pulls the bank statement instead of looking away. By the attorney who spends 16 years in a public interest practice when she could be billing $580 an hour. By the FBI agent who sits in the 3rd row of a courtroom and waits. By the bailiff who knows exactly when to say one word and mean it entirely. Daniel Reyes did not have powerful friends. He did not have an expensive lawyer or a litigation bag full of pre-filed motions. He had a manila folder, a legal pad, 22 years of showing up, and the specific courage of a man who has decided that the truth is worth more than his comfort. That courage is not rare because people don't have it. It is rare because the world spends a great deal of energy convincing people not to use it, convincing them that the system won't listen, that the powerful always win, that the cost of telling the truth is higher than the cost of staying quiet. I have sat in this room for 43 years. I have seen the system fail people in ways that kept me awake at night. I am not here to tell you it is perfect, but I am here to tell you that on September 9th in Courtroom 7, the truth traveled exactly 47 minutes and 22 seconds from an elevator camera to a projector screen. And it was enough. It was enough to give a man his life back. It was enough to protect a 16-year-old girl with a Brave Crew shirt. It was enough to remind everyone in that room, myself included, why this bench exists. You may not sit on a bench, you may not wear a robe, but you will have a moment, perhaps you are already in it, where the easier choice is silence. Daniel Reyes chose differently. So can you. If this story moved you, subscribe to this channel right now. Every week I bring you a case from this bench, and every case carries a truth that someone out there needs to hear. Leave me a comment below. I want to know, have you ever had a moment where you chose to tell the truth when silence would have been so much easier? What happened? Tell me. Those stories belong in this community. And if you know someone, a friend, a family member, anyone, who is sitting at a metaphorical kitchen table right now looking at their own version of a bank statement and wondering if anyone will believe them, share this video with them today. They need to see that the truth finds its way. It always does. I will see you in the next case. Justice isn't a hammer, it's a mirror. Court is adjourned.